University School of Law, and the paper that I just presented is titled right now, the tentative title is an Economic Perspective on Preemption. And what I've tried to do in the paper is set out a very simple economic model of the preemption problem, the problem from the perspective of a court. And I've examined the problem as a choice between regulatory regimes. And I tried to design an objective function for the courts that would determine the choice of regulatory regime. I've taken that general theory to identify the components, the factors that should determine the choice between regulatory regimes. And then from there, I've tried to take the implications of that model for a preemption decision before a court. What kind of rules of thumb should a court follow in trying to decide whether to preempt a case? I've generated several rules of thumb. I've found that the case law appears for the most part to be consistent with those rules. And I've also done further work in this area, an empirical study that was published earlier in the Supreme Court Economic Review that also finds evidence consistent with the rules of thumb that I've set out. And I've given a name for these rules. I've called it the congruence model of preemption. And then the latter half of my paper was simply looking at political problems or doctrinal problems that are sitting over the preemption case law as it exists, because much of that case law is based on the notion of the supremacy clause and congressional intent. And I think having those sources of law as the most important foundation for preemption doctrine creates a problem, because those are some fairly unstable sources of law. Having congressional intent being an important factor in the preemption analysis means that parties who work with Congress on statutes will attempt to influence the language in those statutes, to influence the statutes, to control the preemption decision that courts have to make later on. And so the proposal that I end up with is a suggestion that courts move away from that, from this problem, that they try to find some common law basis for the preemption decision. It could be a regulatory compliance defense, it could be some other kind of defense, but one that decouples the preemption decision from the supremacy clause issues that have been troubling a lot of the case law in this area. So I think that's largely the heart of what I've said in this paper.
Sure.
One of the things I want to go back and take a look at is this issue about state judges versus federal judges, and the question of whether elected judges present a problem versus appointed judges. So I had a few people suggest to me that maybe my theory is unworkable in some contexts. Maybe the factors that I'm asking judges to consider can't really be considered in an objective manner by some judges. Maybe judges are constrained by some pieces of the law that are out there from adopting the proposal that I offered at the end. So that's one of the things that I want to go back and reconsider. So I want to look into whether that's a problem, that the processes by which certain judges are put into office may present certain biases that those judges find it hard to avoid, or that other judges are constrained in such a way that they can't adopt or can't move toward the reform suggestion that I offer at the end of the paper.